Good afternoon, everyone. Thank you so much for joining us today for our 2-hour law webinar. Just a few housekeeping items. You will receive credit for this webinar in about 7 to 10 business days. I hope everyone had a chance to list all names who are sitting in on this webinar when you were able to get on the webinar. It had asked. If you did not, please call us. Also, if you have questions during this webinar, you'll see the question box on the right-hand side of your screen. Please feel free to type in questions as the webinar is going, and I know Tom's going to stop every once in a while and answer those questions. At this time, I would like to welcome Tom Fuller, who everyone knows. Tom is the director of the New York State Bureau of Funeral Directing, and I'm sure has spoken to the majority of you at this point. Tom, we're so thankful you were able to do this webinar for us today and give those that haven't received their 2 hours of law that opportunity. So welcome.
Thank you. Appreciate the opportunity. This is the last law CEU I'll be doing for this biennium. And then after July 1st, the next time I speak, I believe, is going to be at the New York State Convention. And it'll be all new material for the next 2 years. Not new material per se, because the law doesn't change that much, but new to us as far as giving these presentations. Over the last 2 years, I've talked about this topic, this 4201, mainly because it's one of the most common areas of questions we get, and it's also the basis of a good portion of the consumer complaints we get as well. So we'll talk about that as we get into it further. But today we'll try to get through the entire section 4201 of the public health law. Just to clarify, this is public health law. This is a law that was crafted by the legislature, voted on, passed, signed by the governor. That's what a law is. Oftentimes, I think in the biennium prior to this one, I talked about misconduct, which comes out of the regulations. So the regulations underlie the health law, and there's places where there is overlap, just to make sure that you understand that this is public health law, and laws take a little bit of effort to change. There has been a change to this. I'm going to have to modify what I tell you today in one little area, because on May 9th, a law was signed by the governor, a slight change to 4201, and we'll get to that when we get into subdivision 2. So that's where I'm going to start. There are subdivisions. The law is broken up into various sections, which are known as subdivisions. There are 11 different subdivisions of 4201. Some of these we won't spend a whole lot of time on. Some of these we're going to spend a lot of time on. So just give you a summary of where we're headed. The first section deals with definitions. You would think that would go pretty quickly. There's only actually 4 definitions that we're going to discuss. One of them is just 7 words. One of them is going to be close to 7 slides. So we'll get to those. Part that most of you are familiar with, when you hear the term 4201 and you think about this section of law, most of you are familiar with what we call the priority of rights. Some of you refer to it as the hierarchy. This is the list of those who have the rights to control disposition. And this entire section of law is about the disposition of the deceased and who can control that. That person is known as the agent. So the next section that you're probably familiar with is how you can appoint an agent prior to death to be the person in control of disposition, which will ultimately alter that hierarchy that we're going to discuss in subdivision 2. So we'll spend a good amount of time on that, and then we'll reference that quite frequently. Then there's some other areas about wills and agency and how these two play together. Prior to the passage of this particular section of law, wills were pretty much the only way a person could appoint somebody in writing. How is agency revoked, and what can change change the status of a person who's claiming priority? And we're going to get into a couple of areas that are going to be very beneficial for you to understand, and it deals with some of the protections that are afforded you through the public health law. As a funeral director, there are things that you need to be aware of that you can be held liable for in court if you don't do things correctly. But there are some sections here. This good faith of the agent is the first one, is a protection to the person acting as agent. And there's some overlap with what you are expected to do and how you're supposed to work with that person that will protect you. But then subdivision 7, and I'm going to refer to this throughout this presentation today. When I talk about subdivision 7, for those of you in the audience out there that are taking notes, make a note to yourself, subdivision 7, because this is the good faith of the funeral provider. There is a protection here for the funeral director, protection from civil liability. And again, I said at the beginning, this is an area where we get a lot of consumer complaints, and it'll talk about how you can be protected from being sued in court by implementing this particular section with the proper documentation. I'll refer to that again over and over as we lead up to it, because it's a very important aspect. Number 8 is disputes over agency. And as I was saying, a good percentage of the consumer complaints we get tend to be family disputes. I'm sure you're all familiar with those. And there's not a funeral director out there who been in the business more than a few months hasn't run into families that have some dysfunction, and part of the family wants one thing, part of the family wants another thing. There's a dispute over who's going to be in control. And this will give you some guidance on how to handle those disputes. Not only are they the most common complaints that we get, but they're also the most common questions we get from funeral homes. Don't ever be afraid to pick up the phone and call us. We'll walk you through and try to guide you in where you need to look at the law when you have an issue like that. But ultimately, it seems like in a lot of these situations, it's the one part of the family that's not getting what they want. We'll try to pull the funeral home into that dispute and make them liable for their issues. Oftentimes, there may be a underlying reason for an actual complaint or a referral for enforcement, but a lot of times it just boils down to families not getting along and not able to decide who's going to be in charge. We'll talk about that in a lot of detail when we get there. A few wind-up things toward the end of this presentation. Priority of pre-need law. We'll discuss how pre-needs can affect agency. There's a section dealing with protections to organ donation, and then finally just protections for the funeral contract. That's our last slide. So there's going to be, or our last subdivision. So there's going to be 11 subdivisions that we're going to try to get through today. And I think at this point we can just jump right in. And if you recall, the first subdivision is definitions. So some of the definitions. Now, first of all, I want to point out when you're dealing with law, when you see a section of law and it starts out with a series of definitions, that's important to understand that those definitions apply only to that section of law. So the definitions you're about to see here deal only with how things are defined in 4201. For example, this first one, it's one line, 7 words. Cremation means the incineration of human remains. That sounds pretty straightforward. Now, sometimes we'll get a consumer will call and say, well, I've been looking online and I found the definition of a particular topic, and this is what the law says this means, and this is why the funeral home needs to do this for me. And they'll pick a definition from another section of law entirely unrelated. They might even pick something from the vehicle and traffic law. So to bear in mind that when you're dealing with legal definitions, they often are very specific to a particular section of law. Just for example, the term cremation here is very clearly defined, incineration of human remains. In the not-for-profit corporation law, which governs crematories and cemeteries and the division of cemeteries, the term cremation has a slightly different definition. In fact, it's a lot more than 7 words. It's means a technical process using heat and flame that reduces human remains to ashes and other residue, includes the processing and may include the pulverization of such ashes and other residue. So it's a lot more detailed under the cemetery law, what the definition of cremation is. In fact, there is a bill in the assembly now. I don't believe it's going to be up for a vote in this particular term, to change the definition of cremation in the not-for-profit law. In other words, under cemetery law, to include any other technical process to reduce human remains. So we're talking about alkaline hydrolysis, human composting, and those types of things. So the definition of cremation here is only to be applied as we talk about it under 4201. So the second definition is also fairly short, just this section, what you're seeing here. And you would think this was pretty straightforward, but I want you to think about it. Now, I'm going to read it for you first. Disposition means the care, disposal, transportation, burial, cremation, or embalming of the body of a deceased person and associated measures. That's a pretty short and concise definition, but it says a lot. Normally, when you talk about disposition, I mean, as funeral directors, we usually refer to disposition as burial, cremation, or body donation. And obviously the word disposal is in this definition. It's the same, they got the same root word, disposition and disposal. So we're talking about what happens to human remains. What's left by a person when their life is gone has to be disposed of in some way. So why does this definition then talk about care, talk about transportation, talks about embalming? There's no place else you're going to see embalming defined as part of disposition, because embalming is not required by law. We get complaints from consumers sometimes about embalming. I got one in yesterday. The entire complaint said they did a terrible job on my mother. She looked horrible. It was the entire narrative of the complaint. We have to reach out to this family and say, well, we don't regulate embalming because we don't require embalming. We don't certainly regulate quality of services. But embalming is included in this definition, which is interesting when you think about it, and associated measures. So think about why this particular definition in 4201, which deals with the rights of the agent and agency, the person in charge of disposition, why would they want to expand the definition of disposition? Well, the simple reason is because when somebody is in control of disposition, they're not just making the decision whether to bury, cremate, or donate the body. They're making all the decisions. It's a way of saying, for this section of law, anytime we talk about disposition in the next 10 subdivisions here, this is what we're referring to, not just burial, cremation, or donation. We're talking about the right to control embalming, the right to control transportation, for the care of the body, for associated measures, which could include, of course, funeral services, visitation, choosing the cemetery, those things. So disposition seems like a pretty small idea when you first talk about it. But as you see here, any place in 4201 where they talk about disposition, they're expanding that to mean that person in control of disposition also has control over all these other aspects. So the third definition we're going to talk about is not as short as these two. And that's the one where I would say we get frequent calls, and that's about domestic partners. Now, I'm going to have to break this up into some sections here because it is a rather lengthy definition, and this definition doesn't just stop with a full definition. It even goes into what I call a negative definition, explaining what a domestic partner cannot be. But we'll start with this. A domestic partner means a person who, with respect to another person, one, so to this paragraph, there's a subparagraph 1 that says they are formally a party in a domestic partnership or similar relationship with the other person, entered into pursuant to the laws of the United States or any state, any local, any foreign jurisdiction, or there's an or in the middle of this and one at the end. We'll get to that. So far, we'll stop there. We'll pause. Formally a party in domestic partnership or similar relationship with another person, entered into pursuant to in other words, under the laws of the United States, any other state, any local jurisdiction, any foreign jurisdiction. So they're going to recognize any law that talks about domestic partnerships and recognizes that relationship. Then this first or says, or registered as the domestic partner of the person with any registry. So it doesn't have to be under a particular law. It can be some kind of registry that's maintained by the employer of either party. In other words, either one of these domestic partners, if their employer has a registry saying you can register your partnership with us for the purpose of employee benefits, or a registry of any state, municipality, or foreign jurisdiction. Again, there's another or, but before I move on, not all states have a domestic partner registry. Not all municipalities do. New York City does. In fact, I have a lawsuit I will be talking about later when we get to subdivision 8 about disputes that deals with that particular concept. So there are places where they can enter into a registry, they can have an agreement under the laws of their locality. But if they don't have that, there's an or at the end of this subparagraph. And this is subparagraph 2. It says, is formally recognized as the beneficiary or covered person under the other person's employment benefits or health insurance. I know this is starting to sound like a lot of just wordy stuff. There's another or at the end of this. So quickly, they can be under the law of the local locality, they can be on a registry. If those two don't apply, they can be formally recognized as a beneficiary covered person under their partner's employment benefits. So in other words, the employer doesn't have to have a registry. All he has to do is offer benefits to their partner, and that would qualify them as being recognized as a domestic partner. And then subparagraph 3 gets a little more involved. Subparagraph 3, this is again or, so it's not you have to have 1 and 2 and 3. It's 1 or 2 or 3. And 3 says, if these individuals are dependent or mutually interdependent on the other person for support, as evidenced by the totality of the circumstances indicating a mutual intent to be domestic partners. And then we're going to get a little bullet list here. So it's including but not limited to. And I'm going to give you some bullet points here. And the thing I want to emphasize as we go through this, these first 3 subparagraphs, it can be 1 or 2 or 3. And 3 is going to give you a list of qualifications. The mistake I don't want you to make is to think that when you're looking at this law, especially in this subdivision or subparagraph 3, that a couple has to check off all the boxes. These are just things that can indicate. This is not a list where, you know, if they miss one item, they can no longer be considered domestic partners. So we'll get into some of the details here, and then I'll pause for questions because I always get a lot of questions in this area. So first of all, common ownership or joint leasing of real or personal property. A couple is somebody sitting before you claiming to be the domestic partner of the deceased. That's one of the things. First of all, they share a home. Actually, that's the next bullet point. Common householding. So if they not only have common householding, but they're both on a lease or they both own property. For example, my son and his partner bought a house in common last year in Baltimore. And she's on the deed just as equally as my son is. So they would be considered domestic partners in this situation. Plus, of course, they have common householding. So common householding is kind of the whole basis initially of the idea of a domestic partner. It's where you're domiciled. Your partner domestically, you have a common household. You share the same dishes, you share the same TV, you share the same furniture. You may have even more deeper ties when it comes to income and expenses. So shared income, shared expenses, common householding, common ownership, common leasing, those are all indicators. Here's a good one, children in common. That's a pretty good indicator that they're domestic partners. I had a funeral director call a while back, was trying to wrap his head around whether or not the person he was dealing with was claiming to be a domestic partner would count. And he kind of went through this list with me, and he said, well, they don't have any children, so I don't know if I can consider them domestic partners. Well, they've been together for 20 years. They were both, on the same lease, everything else indicated they were. In other words, like I said earlier, you don't have to check off every box. Signs of intent to marry or to become domestic partners under paragraph 1 or 2. In other words, they're engaged, they set a wedding date, anything like that. That's certainly signs of intent to marry or intent to become domestic partners under those first 2 paragraphs that we talked about, subparagraphs, that is. The one that said they have entered into agreement under the laws of any municipality, state, whatever, and subparagraph 2 that said, any kind of a registry with their employer, et cetera. So there's signs of intent to become domestic partners. That would include that. I had a situation some years ago where a young man was killed in a work accident, and mother and father came in with another young lady and started making arrangements. And during the conversation, it became apparent that the young lady that was with them was the fiance of the deceased. And not only that, not only were they engaged, they had been living together for over a year. So at that point, conversation stops and it becomes, well, this young lady is now in charge. Mom and Dad, thanks for coming. You can stay if she's willing to have you stay. But she's the one that's going to be making the arrangements at this point. So that's an important thing to remember. And the last one they put in here is the length of the personal relationship of the persons. Now, this question definitely has come up more than once at the Bureau, where funeral homes have called and said, yeah, they're domestic partners, but they've only been together for a few months. Well, the law can be very specific, but unfortunately, the law can also be very wide open in areas. And here's a good example of that. Sometimes I think the law is intentionally left broad, and they allow the courts and the judges to fine tune it. Here's a good example of that: the length of the personal relationship. It doesn't say they have to be together for a year. It doesn't say 101 days. It doesn't say any time less than a month will not be considered a domestic partner. None of that applies. It just says the length of the personal relationship of the persons. And it doesn't even say the length of common householding, the length of time. So it's kind of a wide open qualification, but it's something that can be looked at and added to that list. And again, you don't have to check off all the boxes. This is more along the lines of preponderance of the evidence, if you want to put it that way. It's not a strict list of things that have to be in place for them to be considered domestic partners. And I think before I go on to the next section, this paragraph goes on, this paragraph C is going to go on for another slide or two. But before I go too far along, I'm going to pause and see if there's any questions on what we've talked about so far.
So I do have one question so far. Can alkaline hydrolysis be done in a funeral home who is willing to purchase the equipment?
At this time, that has not been dealt with, because for those of you who don't know, I also sit on the cemetery board. The cemetery board meets every month. It's made up of, it's actually made up of the Secretary of State, the Attorney General, and the Commissioner of Health, or their designee. And so there's 3 of us on the board. We are all designees of those individual office holders. So I represent Dr. Bassett on the cemetery board, and preliminary discussions about this pending legislation is that it's going to be an amendment to the not-for-profit corporation law, which governs crematories, cemeteries, etc. So as a mode of final disposition, right now they're looking at it as something that would fall under Division of Cemeteries. So, and just like crematory law, when it changed in the 70s to say, funeral homes could not have the equipment to do cremations, they had to be kept separate. It had to be a not-for-profit thing, and we all know there's some firms that are grandfathered in, of course. But my understanding is they're looking at it right now that would be completely under the Division of Cemeteries, and unless there is a change through the legislature to expand that to funeral homes. There's also talk now of human composting, and I know in some states where they've passed that, I think Washington was the latest one. Funeral homes are putting in the equipment to do the organic reduction, as they call it, for human composting. But I don't see that happening in New York State, but I could be wrong. Again, we can't guess what the legislature may or may not do. And if it's something that funeral homes want to pursue, they can always, make the case known to their to their legislators and see where that can go. So hopefully that answers your question. And Kelly, if there's no more questions?
No, there are. They came in after. Okay. This is a long one. How does the funeral home determine if a domestic partnership exists without written proof in a disputed family relationship? How does the funeral home get proof of the domestic relationship? Can a funeral home request proof? What about parents of a child who are not living together with the deceased who is living with someone else?
Okay, I'm actually, even though there's a lot to that, I'm glad that was asked because I was going to go down that road too. You know, I said I'm going to do this in two parts. The part about the parents, we'll talk about that when we get to priorities and subdivision 2. As far as domestic partners go, now, and I said this is this bullet list you're seeing on the screen now is more of a preponderance of the evidence, and you know you don't have to check off all the boxes. But here's the point that I was going to make at the very end, but I think this is a good point to a good place to do that, and it's a good response to this question is this is not a decision that you make, and I want to emphasize that strongly. As a funeral director, you are not going to be the one making this call. You don't adjudicate this unless you want to be liable for some kind of civil action down the road. So in other words, somebody comes before you and says, I am the domestic partner of the person who passed away, and there's a dispute among the family that's not true. You know, you're not the domestic partner. There is a way to deal with that, and we'll get to that on subdivision 8. So if you're taking notes, I said subdivision 7 is important. Subdivision 8, we're going to deal with how you handle those disputes. But please bear in mind, you do not make that call. You're going to let the family make that call. And if there's no dispute, that's great. But you're going to have to document that. And that's where I get to subdivision 7 there. I said I'm going to bring that up multiple times. There's a step you have to take to protect yourself. And if you do make that decision, if you do say, well, I'm going to rule this person as a domestic partner, and the part of the family that's disputing this, they can just leave, you could be open for civil liability because this is not your call to make. You're going to have the family make that call. You're going to have the person claiming that make that call, and they're going to have to document that. And there's a form, and I'm going to throw it out there now and jot that next to you where you wrote down subdivision 7, good faith of the funeral provider. It's called the at-need written statement of the person in control of disposition. And they've got that form online. You can put your own letterhead and logo on the top of it if you want. I know the New York State Association has a version of this. I believe it's even on their website that you can download, the at-need written statement. So this is where this person coming before you saying, well, I'm the domestic partner and I'm taking charge. Have them sign that. Have them sign that. And every call you do, you should be having somebody sign that because that's your get out of jail free card when we get to subdivision 7. And I've actually got a lawsuit, a civil suit that I'm going to discuss when we get to subdivision 8 regarding that. So I appreciate that question because the more I can hammer that home over the next hour and whatever time, 30 minutes we have, it's going to be important. So good question. I appreciate that. Kelly, is there another one before I move on?
Yes, there is. We have a hospital in this area that won't release a body to the funeral home unless a blood relative okays it. Are they violating this law?
Wow, I haven't heard of that. And a blood relative. Well, 4201 says who's in charge of disposition. Now, they can have their own internal rules about things, but I think they're really pressing it there. That might be a good area where your local association could band together and send a letter to the administrator questioning that policy. That's not a law, that's their own internal policy. So that's kind of outside of the scope of what we're doing here, but yeah, that would be something I would certainly also be concerned about if I was facing that situation. Whether or not they can do that, that may be something might take up with the Division of Hospitals. I don't know what leeway they have to make rules like that. Certainly, once the family calls a funeral home, they shouldn't be questioning Well, I'm sure they must be questioning sometimes if the person releasing the body has that authority, but that's something that should be dealt with at admissions, I would think. I mean, that's just my personal opinion. That's not state law that I'm aware of. So I don't know if I answered that or not, but I hadn't heard of that.
And then one
Okay.
more. I thought we were a common law marriage state. Isn't this a blurry area in regards to that law?
Actually, good question. Because usually at the beginning of this particular definition, I talk about that, and I forgot this time around. New York State, a lot of states do have what they call common law marriage. And it might even be put into statute where it says, you know, a couple lives together, acts as common householding, et cetera, for an X number of years, they are considered legally married. And in those states, if they dissolve that partnership, they have to go through an actual divorce. New York State has never had common law marriage. Part of the reason 4201 came around was because we didn't have common law marriage. And also, this whole thing kind of grew out of the early 80s during the AIDS crisis, where there were situations where back then same-sex marriage was, of course, not legal at that point. And there were situations where there were individuals who spent their entire lives together, common householding, common leasing, shared income and expenses, the whole 9 yards. They had a domestic partnership, but then when one of them died, the other one was completely cut out of any decisions. So part of the reason Department of Health and the state came up with a definition of a domestic partner and gave them specific rights is to deal with that situation, since we did not have common law marriage and same-sex marriage was still illegal at that point. So yeah, that is a good question. I'm glad you brought that up. Okay.
Okay, that would be it for now.
Okay, so moving on this particular section here, I'm just going to back up a little bit so you can see where we're at. We're in we're in the third definition of domestic partner. We've had 3 paragraphs explaining some of the things that can be included in making that decision, or how to determine whether a person is a domestic partner. And then we are going to go into an extension of that last subparagraph that talks about what a domestic partnership cannot be. And it throws in this caveat here: each party to a domestic partnership shall be considered the domestic partner of the other party. In other words, it can't be a one-way street. You can't have somebody say, I'm your domestic partner, but you're not my domestic partner. So it's a two-way thing. The minds that craft laws have reasons for what they do. I'm not exactly sure what the reason was for that, but it makes perfect sense. So this last section of that subparagraph says, and I'm going to read it for you, and then I'm going to break it up slowly. Okay. Domestic partner shall not include a person who is related to the other person by blood in a manner that would bar marriage to the other person in New York State. There's a period. Domestic partner shall also not include any person who is less than 18 years of age. There should be a period there, but or who is the adopted child of the other person, or who is related by blood in a manner that would bar marriage in New York State to a person who is the lawful spouse of the other person. Ooh. If that doesn't make it clear, I don't know what does. It's actually quite confusing language here, but it's when you break it up and unpack it and take it in small bites, it actually makes a lot of sense. And so that's what I'm going to do. Now, let's think about the fact that when we're talking about domestic partner, we're talking about our situation as funeral directors. Somebody's coming before you and they're saying they're the domestic partner of whom? Well, it's going to be the deceased, correct? So somebody's claiming to be the domestic partner of the deceased. So you'll see in this paragraph, they use the word person or other person in every line except for the second to last line. They use it twice in the last line just to make up for that. So let's break this up. In every place where it says other person, to clarify, we're going to use the term deceased person. So let's start with that, and we'll take it in smaller bites. So domestic partner shall not include a person who is related to the other person by blood in a manner that would bar marriage. So let's start with that one. and see if that makes more sense to you. Domestic partner shall not include a person who is related to the deceased by blood in a manner that would bar marriage to the deceased in New York State. Now that seems a lot more clear. I had a complaint from a young woman. I don't know exactly how old she was. She called and complained to the department that her dad had died, and her aunt had made all the funeral arrangements, had him cremated, and then notified the family that he was gone. And she called us wanting to file a complaint against the funeral home because she actually looked up 4201 and said, I was the person that should have had the right of disposition. My aunt had no reason to do that. And before we passed judgment, I didn't know whether her aunt had been appointed as an agent, as we'll talk about in subdivision 3, or if there was some other mitigating factor. So I contacted the funeral home and we got discussing this. And first question is, Mr. Funeral Director, why did you let this deceased person's sister make his arrangements? And his response was, well, they were domestic partners. I said, how do you figure that? Well, they lived together. After his wife died and she was divorced and they got older to save money, they moved in together. So they were common householding, shared expenses. They even had a joint checking account. So yeah, she was the domestic partner. So what happened here was this individual funeral director broke that rule about being the one trying to adjudicate this thing. And he didn't read all the way down this section of definitions to where a domestic partner shall not include a person who is related by blood in a manner that would bar marriage in New York State. In New York State, you still cannot marry your siblings. I won't speak for other states. There may be places where that's legal, but I don't know. Certainly in New York State, you cannot marry a sibling. So that would have thrown that particular one right out the window. The funeral director should have been aware of that and should have pursued some more information rather than trying to make that call. So yeah, that funeral director certainly could have been liable for civil action. I don't believe the daughter ever did take it that far, but she was correct in the fact that her aunt should not have made those arrangements. The second part of this paragraph says the domestic partner shall also not include a person who is less than 18 years of age. Okay, so that one's pretty straightforward. And we don't have to use the substitution of other person with deceased person. But then we get into a little bit more here. Who is the adopted child of the deceased person? Okay. I said you can't marry a sibling. You also cannot marry one of your children. And in New York State, an adopted child has the full rights and full standing of a naturally born child. That question actually came up under 4201 a couple of times, where somebody wanted to know, okay, there's 4 siblings sitting in front of me. There's 3 natural siblings and an adopted sibling. So what do I do? Adopted sibling is the same as a natural sibling. I'm sorry, child. So they have the same rights, which brings us to this fourth one. I want you to think about this. I'm going to read it slowly. We've substituted the other person with deceased person. And think about what this is saying. Domestic partner shall not include a person who is related by blood in a manner that would bar marriage in New York State to a person who is the lawful spouse of the deceased person. Think about what that's saying. And why would this be in here? Okay. What person could be related by blood to the spouse of the deceased and be claiming domestic partnership? Especially if the spouse of the deceased is already predeceased. So somebody dies, somebody comes into the place and says, I'm the domestic partner because I was living there. How are you related? Well, my mom was his wife. Let's use that example. So what we're discussing here is a stepchild, a person who is related by blood in a manner that would bar marriage to the spouse of the deceased. That's a stepchild. Now think about number 3 is an adopted child. They have full rights as any natural born child, but a stepchild does not. You can't marry your adopted child, but you can marry your stepchild. And if you don't believe me, look up Woody Allen. Woody Allen married his stepdaughter. He was married to Mia Farrow, who adopted a child, but Woody Allen never adopted the child. So that child was then a stepchild, and he ultimately left Mia Farrow and married the stepdaughter. So this is what we're discussing here. And this brings us around back to that original question. If you have 4 people come into the funeral home to make arrangements, well, and this is going to change now because of some legislation that just got signed last week, in fact. Used to be, and I'm kind of letting the cat out of the bag early, used to be everybody had to agree on it. And I had a funeral director one time say, well, there's, that whole thing with there's three siblings and a step sibling or an adopted sibling. They all have equal rights at that point. Now that may have changed now. But if it was the same situation with 3 children and a stepchild, the stepchild has no standing under 4201. So hopefully that's clear. So that original paragraph that seemed rather complicated, I think now when we break it up and chop it up into bits like that and use the deceased person instead of other person, I think it makes a lot more sense. And before I move to subdivision 2 about priority, I said there was 4 definitions. We only dealt with 3. The 4th definition, I didn't even put in the slides. Over here somewhere. Yeah, 4th definition, I'll just read it to you, is person. The definition of a person, because it keeps talking about a person this and person's employment and person that. Person means a natural person 18 years of age or older. That's the entire definition. Person means a natural person 18 years of age or older. They don't define what a natural person was as opposed to an unnatural person, but that's that definition. So before we move on to priorities, subdivision 2, Kelly, is there anything else on these definitions before we?
Yeah, there were 2 questions that came in. So when a person is still married for insurance purposes for the spouse and children, but the couple is separated, if the husband or wife has a new partner and wishes for the new partner to be in charge of their disposition, is an at-need agent form suffice for the new partner to have control?
Yes, actually, as we get into priorities, that's going to be something I will definitely discuss, especially when we get into subdivision 3 about the appointment of an agent. The appointed agent, a written appointment of an agent supersedes everything. That situation happened to me a few years ago when I was in Tompkins County. We had a side business called Ithaca Cremation. And a gentleman and a lady came in to make the arrangements because he was been diagnosed with a terminal illness and was entering hospice. And they made arrangements for this direct cremation. And then he made the comment to me, we want everything done as quickly as possible when the time comes before my spouse can find out. And wait a minute, what spouse? Oh yeah, I'm still married. I've been with my partner here for several years, but I'm still legally married. And at that point it was like perfect timing to bring up this appointment of an agent. So we did that. We executed the appointment of an agent form, the 5211. And a few weeks later, when he passed, we completed the arrangements, and the domestic partner contacted the estranged wife and told her that he was gone. And did she call us up and scream and yell and threaten to sue us? Absolutely. Did her attorney call and scream and yell and threaten to sue us? Yeah, he did too. Ultimately, we sent him a copy of the 5211, and that was the end of it. So yes, there is that situation that comes up a lot more often than you'd like to know. We'll get into that shortly here. What was the other question, Kelly?
Sure, there's actually 2 more. Okay. If a lady comes in for arrangements claiming to be the wife of the deceased, signs cremation forms, etc., then we get a call from the wife who faxes over a marriage license. The deceased living with the lady claiming to be the wife, but he was still legally married to the other lady who was involved with both ladies. Who do you take direction from?
Yeah, honestly, this has actually just happened not too long ago. You're going to take direction at this point from a judge. And when we get to subdivision 8 about disputes over agency, that's where these things have to go. As soon as you become aware that there is a dispute over agency, especially in something as potentially explosive as this, well, stay tuned. We'll get to subdivision 8, I promise, even though we're 45 minutes into it, we're still just finishing up subdivision 1, but we will get to that, I promise. How to deal with those kinds of disputes. Is there another one before I move on?
Yeah, and I know we're going to get to this later on as well, but I will ask a question. If 5 siblings can't agree on disposition of a deceased mother, should we turn them away until they decide, cater to whoever is paying, or is it majority rule?
That is a good question, and that's where we're moving right now. And it's very timely because last Monday, the governor signed a law changing what I was going to say this week. So, yeah, that's a good question. We'll get to that in, I think, the 3rd or 4th one down here. I have a copy of the new section of law right in front of me. I printed it out this morning to make sure I had it. All right, here we go. Subdivision 2 is the priority of rights. So the very top of the list, and you should be familiar with this list. I'm under the impression that Division of Cemeteries will be updating their 3-page cremation authorization form, the 1898 DOS, because they have this language in there. And like I said, the governor just made a slight adjustment to this by signing that legislation. But for now, this is still intact. The person designated in a written instrument executed pursuant to the provisions of this section, and the section being 4201, has the highest priority. So that person, if you have, and this is a great thing to do when you're doing pre-arrangements. When we get to the next subdivision, appointment of an agent, I'll probably bring that up again. A person prior to death appoints somebody in a written instrument under this section. We have the form on our website in both English and Spanish. It's called the DOH 5211 form. That person always has priority. And then number 2 is the decedent's surviving spouse. And we've talked in the first section about a domestic partner having the rights, but this is where I'm answering that question that came up. It happens more frequently than you'd probably want to know. We get calls like this on a fairly regular basis, every couple of months, where there is a domestic partner, but there's also a surviving spouse. So you see number 2 is the spouse, and number 2A, not exactly equal. It's actually indented in the law to emphasize the fact that the decedent's surviving domestic partner has the rights in the absence of a surviving spouse. And I call this the $255 question, who's in charge? Because what are you going to put on the death certificate? This is sometimes how this comes to light. I've had more than one funeral director call and say, yeah, I was filling out death certificate information on my worksheet with this individual, and when it came to surviving spouse, they were evasive, and it turns out this person is still married, even though they've been living with this other individual for several years. That surviving spouse still has the rights. So this is where it becomes, now they don't always care, and they may sign off on everything. If that's the case, document everything. If that surviving spouse, if you call that spouse or the family calls that spouse on speakerphone or whatever, and that person says, I want nothing to do with it, and hangs up, you're good to go, to be honest. Because we'll talk about that. If the person is unwilling or unable or unavailable, you can go down the list. But so that is an important one to remember. You do run into that. In fact, I had one, I had a phone call from a funeral home where not only were they domestic partners, they had 2 children in common, but the gentleman that had deceased had never actually finalized his divorce. So the third one is any of the decedent's surviving children 18 years of age or older. And this will go back to that question that just came up. that person requested clarification on. So if you have multiple children, up until May 9th, the law used to say any surviving child 18 years of age or older. Now there's an amendment to that section of the law. The following persons in descending priority shall have the right to control the disposition of the remains of such a decedent, and here's the change, provided that if there are more than 2 members of a class listed in subparagraph 3, which we're looking at now, 5 or 7, we'll get to shortly, of this paragraph entitled to control disposition of the remains of a decedent, the disposition shall be determined by a majority of the members of the class who are reasonably available. That's kind of a big change. It's just one line that they added in there, but it says subparagraph 3, 5, and 7, if there is a dispute, majority rules. Now, prior to this, it was always, yes, they all had to agree. In fact, one of the lawsuits that I had printed out and I've used for the last 22 months in these presentations was Rakow versus the state of New York, was about a lawsuit right along those lines where there were 4 siblings. One of them didn't want an autopsy. The other sibling said, yeah, let's do it. The autopsy went forward, and she sued the state hospital for doing the autopsy and was successful. But now she wouldn't have that right because she was overruled. So it is majority rule now. And it says 3, 5, and 7. So if you're jotting notes, we'll get to these 2. So there's 3. So now it's the majority of the surviving children 18 years of age or older. So I'm going to have to change this slide if we ever circle back around and start doing this presentation again, some biennium down the road. Either of the decedent's surviving parents. Now, this new change doesn't apply to them because you can't have a majority of parents. There's only 2 parents. So if, and this happens where the surviving parents come in to make arrangements, they've been separated or divorced for some time. They're talking about an adult child that didn't have a spouse or domestic partner or anything else, and the parents hate each other and they don't speak. I had a call probably about a year ago, this exact same situation. One parent wanted burial, one parent wanted cremation. Then they finally agreed on cremation, but then the one parent wanted the ashes buried in their cemetery with their family, and it just got crazy. So there's no way you can have a meeting of the minds. In this case, you have to defer to subdivision 8 when we get there about disputes over agency. So I said 3, 5, and 7. Here's 5. So if the decedent doesn't have a domestic partner or spouse or any children, any parents, then you can go to the decedent's surviving siblings, 18 years of age or older. And again, it used to be they all had to be in agreement. Now, under this new change of section 1, so paragraph A of subdivision 2 of section 4201, now it's majority rule. Now, I think the question actually said, who do you go with, the person paying the bill or the person who's those are the answers we used to get from funeral homes when we'd have a disputing family member call and say, hey, there's 3 of us here trying to bury or make arrangements for our mom, and we're all 3 siblings. 2 of them want this and I want that, and I didn't get my way and I want to file a complaint. We contact the funeral and say, why did you go with what the other 2 said? Well, one of them was the beneficiary on the life insurance and was paying all the bills. That was not a good excuse. But now when you have the new change where it's going to be a majority rule, that kind of changes how we're going to approach some of these complaints in the future. Number 6 is a guardian appointed pursuant to an Article 17 or 17A of the Surrogates Court Procedure Act, or Article 81 of the Mental Hygiene Law. Not real common, but we have had a couple of those. I had a complaint last, it was during COVID. Somebody was a ward of the state. They had a court-appointed guardian. They were in an institution. They passed away. The institution arranged the disposition, and one of the family members called and wanted us to, pursue some kind of action against this agency for having taken control. But they had all the paperwork in place, and they were appointed pursuant to Article 17. So here's number 7. And again, this is part of that majority rules. This is not real common. This is any person 18 years of age or older who would be entitled to share in the estate of the decedent. Okay, so there could be more than one person over 18 years of age who's entitled to share in the estate. And this is in the absence of all the other 7. There's no spouse, there's no parents, there's no siblings, there's no children. It's just some person entitled to share in the estate. And then we get, whoops, I'm sorry, I hit 2 buttons. A duly appointed fiduciary of the estate. In other words, a person in control of the estate, the administrator or the executor, etc. And then we're kind of getting to the bottom of the barrel of who can be in charge. Any close friend or relative who's reasonably familiar with the decedent's wishes, including their religious and moral beliefs, when no one higher on the list is reasonably available, willing, or competent to act. Important words there: reasonably available, willing, or competent. We'll come back to that at the end of this section here, because there's some caveats that we're going to discuss here. Oh, there's subdivision 7 referenced here. Provided that such a person has executed a written statement pursuant to subdivision 7 of this section. Now, where have we heard that before? And I'm going to throw the phrase out there again: the at-need written statement of the person in control of disposition. So you can go with somebody like this on the list, provided they also sign that statement that they're the one in charge and no one else is available, willing, or competent to act. So subdivision 7 is coming. I will get to it before we're done here. We're almost at the 1 hour mark, and we're picking up speed. We got through some of the heavy weighting. I think we can move a little faster now. And then finally, you get down to the very end of the list. If there's absolutely nobody available, this is when the county steps in and takes over. They are in control of disposition. I know we have quite a number of individuals on this call. I'm going to just peek. I think it says we have, oh, I can't see how many. Oh, okay, it says 356, but that's, I know that's how many sign-ins there are, so there's multiples of that probably. So I'm assuming you're from all over the state. It varies greatly from county to county, and this is a local home rule. Some counties will sign off on cremation. There are other counties that absolutely will not. If you're not sure, because we get calls occasionally, you know, there's nobody available, the county's going to do this, and you know, they're not going to pay me the full shot for a burial. So I want to do cremation, but they won't sign off on it. What should I do? That's something we can't get involved in at the state level. That's a local issue. You know, you and your fellow funeral directors in that area need to work together to address those things. Oh, that's great. I don't know if you can see my mouse, but I'm having trouble. There it goes. It's working now. Okay, so here's some, this is not a new subdivision. This is regarding priority. There's some special notes I want to mention before we go for any questions. Under subdivision 2, there's paragraphs B, C, D, and E, which place some conditions on the list, which was all of paragraph A. So here's some special conditions. So we have this list of who can be in charge and the order they can be in charge, that whole hierarchy. So the first one is, paragraph B says, if the person in control is not available, unwilling, or incompetent, move down the list. Now, we just talked about that a second ago. That was when you got to the very bottom of the list. There's, you know, any friend or whatever that's reasonably familiar, as long as they sign that statement. You might want to make a note there too. If the person in control is not available, unwilling, or incompetent, you can move down the list. Whatever person you land on further down the list, absolutely make sure they sign that at-need statement. Because when you get to subdivision 7, that's your protection. And as I said, I do have a court case I was going to bring up about that, where a funeral home was sued. Second caveat here is a person in control must faithfully carry out the directions of the decedent. I put prearrangements with a question mark in brackets because prearrangements are considered directions of the decedent. Now, sometimes they're not real detailed. Now, if somebody fills out a pre-need for direct cremation, does that mean the person in control can't have a memorial service? Probably not, unless they actually wrote that out in the pre-need. But can they take a full burial that's been a pre-need and change it to a direct cremation? No, they can't do that. So we'll talk about that when we get to priority pre-need law and subdivision 9, if we all are still together at that point. We're at the 1 hour mark now, so I'll take some questions here shortly. We'll get through this section. D says no funeral director may be the person in control if they are also being paid. Now this gives a lot of people some concerns. They're like, I've had this question. Somebody called me and said, I've had a death in my family, and as the funeral director, do I have to do this for free? No, that's not what that's saying. The intent of the legislation was a funeral director could not be appointed in control and charge a fee for that. In other words, you can still bury your own family and they can pay the expenses. That's not the issue. But what they were trying to avoid is that funeral directors might sit down with families in pre-need situations, say, hey, okay, we've got everything that you want for your services and the merchandise and everything else. It's all been selected, but you want to make sure everything goes exactly the way you want and nobody's going to get in the way. Then appoint me as the agent in control of disposition, and my fee for that is only $1,000 or whatever it may be. That's what they're trying to avoid. But what it kind of says when you think of the flip side is that even though a funeral director can't get a fee for being in charge of disposition, it doesn't say nobody else can. So when somebody wants to appoint an agent in control of disposition, that person can say, yeah, I'll do it for $100. That's not forbidden, but a funeral director can't do something like that. And the last one is what we call the order of protection rule. So paragraph E says no person can have control of disposition who, at the time of the decedent's death, was the subject of an order of protection protecting the decedent, or has been arrested or charged with any crime related to the death of the decedent. So let's go look at number 1 here. At the time of the decedent's death was the subject of an order of protection protecting the decedent. This means if the person that died was the one being protected, the one they were being protected from cannot be in control of disposition. We had this call a while back. Funeral director had a situation where domestic issues, I believe they were husband and wife, were going through a very messy breakup, and the husband became violent. The wife got an order of protection to protect her from the husband. As his world continued to spiral out of his control, he then took his life. She came in to make arrangements, and this funeral director went, oh, wait a minute, there's an order of protection. What do I do here? He was fine making arrangements. She was the one that was being protected. Had it been the other way around, he had been deceased, her estranged husband could not have made the arrangements. So hopefully that's clear. And the second one is, has been arrested or charged with any crime related to the death of the decedent. Now, I want to emphasize this doesn't have to be a homicide charge. It doesn't have to be manslaughter charge. A couple of common areas where this has been applied is a DWI death. One partner is driving the car, the other one is the passenger. Car crashes, passenger dies. The one driving is charged with a crime causally related to the death of the decedent. Okay. So there's a common one. A really interesting one that somebody brought up to me few months ago was a situation in which house burned down, a wife was killed in the fire, and the husband was ultimately arrested for arson. And in that particular case, I don't believe he was charged with manslaughter, at least not at the point when the funeral director was dealing with him. But he was charged with a crime related to the death of the decedent. And so it could have turned into a manslaughter charge later. His story was that he and his wife were going to burn the house down for insurance money. So he was admitting to insurance fraud, and he said she just didn't happen to get out in time and accidentally died in the fire. So I don't know if the judge ever believed that story. I'll admit to the arson, but I'm not going to say anything about actually killing my wife. That was an accident. But he was arrested and charged with a crime related to her death. So under this order of protection rule, or under this what I call the order of protection rule, he could not have made arrangements. Okay, quickly now, we'll pause just for a couple of questions, and we'll pick up speed again.
Great. Okay, can a funeral director be an agent where pre-arrangement are concerned if there's no fee? All right.
Yeah, yeah, we'll talk about appointment of an agent. I've been appointed agent for a couple of people in my family, but I was not the one actually handling the services. So I felt comfortable with that. There's nothing that specifically prohibits that. You just gotta be careful about how that's gonna appear and what your relationship is to that individual. And again, the legislature that had that section there, I believe their intent was that they didn't want funeral directors sitting down at arrangements and having everybody appoint them the person in control. Because if you do end up with a dispute, ultimately it's going to be a judge that's going to decide whether or not you were acting properly when you did that. So I don't see anything in 4201 that prohibits it directly, but I would be careful about doing that. Any other question?
Oh, yeah. Okay. We recently had a domestic partner who had a domestic partner and two parents. In the beginning, the parents and domestic partner were cordial and got along. Unfortunately, with the division of cremains, things went a little sour. The funeral home asked for proof, and the domestic partner did send required documentation of her domestic partnership. Also, an attorney for the parents asked for a copy of being a registered partnership. With a state law for distribution, the court doesn't recognize a domestic partner unless they are married. If you are married, you have to register before marriage. Do you think domestic partners should be registered? Also, what happens if the deceased was living with two domestic partners?
Okay. Well, again, I'm going to reiterate what I said before about the funeral director should not be the one adjudicating whether or not they're domestic partners. If somebody's making that claim, make them sign that at-need statement of a person in control of disposition. Then, if it's still being contested, and I had a complainant call me one time, said, "Well, shouldn't the funeral director have gotten a marriage certificate or something like that?" I'm like, no, they're not required to do that. They get a statement, they act in good faith, and that's subdivision 6 and 7 that we're going to talk about. They're covered if they act in good faith and they've got the right documentation. And I'm not saying the documentation has to be, court orders and marriage certificates. It's just that at-need written statement. They said, this person's making this claim. I have no reason to doubt that claim. You do have a doubt. That's when subdivision 8 kicks in and they need to go to a court. And the other part of that question, they brought up the fact that cremains were involved. And honestly, a lot of these disputes we get, everybody's on the same page about the cremation. Everybody's on the same page about the church service or the caterer, all of that stuff. And then when it comes back to disposition of the ashes, that's when things start falling apart. So I'm going to kind of go off the track here a little bit and emphasize to you, when you fill out that CDI, the customer's designation of intentions, be very specific who's going to get the ashes and make sure it's this customer. You have somebody that's signing the itemization, somebody who's signing your contractual part of that. Have them sign that as well. Make sure everybody in the room is on agreement. Okay, I know there's 4 of you here and you all may have equal rights, but let's just simplify things, and why don't you have one person, be the point person on this and get them all to agree like that. Because when we get these calls, I'm about to be sued, people are fighting over the ashes, and I'm going to be sued. Why are you going to be sued? Well, there were 3 siblings, and Johnny came in and picked up the ashes, and then Susie showed up and she wanted the ashes, and I said I already gave them to Johnny, and she said, I'm the one who signed the. Okay, and I stop them right there and say, what does the customer's designation of intention say? Oh, it says return to family. That's the worst thing you can put on there, because they're all family. And now you've made a decision of who's more important than who, when that should have been decided during the arrangements. So you got to be careful with, you got to be careful with that. So, and now the other part I think of that was if they have more than one domestic partner. I haven't run into that one yet. Wow, I don't know about that one. I would again defer to subdivision 8 with disputes over agency, that if you have two people both claiming to be domestic partners, somebody had some kind of relationship like that, then there's a dispute, and the dispute has to be solved by a court of competent jurisdiction. So I think that was it. I think I got everything in that.
Okay. Can a funeral home charge a service fee for pre-need?
No, they cannot. That's under General Business Law 453.
Okay. How much due diligence is required to locate a person who is next on the priority list of disposition? Phone call, 2 phone calls?
It's not specified. Anything you do, document it. And again, if you have somebody else that's, okay, you're trying to find, I know a situation where a gentleman died, cousin came in to make arrangements and said, well, he's got a son, but nobody knows where he is. He's, kind of indigent, homeless. He's been in and out of rehab. We don't know anything about him. We don't know how to get in touch with him. We've done everything we can to reach him. It's the family. The person who's going to come forward and claim responsibility should be the one that's tasked with doing that. That's their due diligence. Again, don't put yourself in a position where you're trying to adjudicate that. Just have them sign that at need. Again, number 7, at need written statement. They're saying there is somebody else. They're not willing, able, or available. So.
Okay. Is DocuSign still a valid way to gain signatures?
That was signed, the technology law, I think it was chapter 7 of the technology law, was changed to allow electronic signatures on funeral documents. Division of Cemeteries has guidance on their website how they still require the signature to be witnessed, even if it's electronic, and they have guidance on their system for doing that. That's not something that public health law has ever actually dealt with. It was actually in the technology law originally that said electronic signatures are valid for everything except for documents pertaining to the disposition of one's body or goods at the time of death. But now that's been changed. That is legal now, yes.
Okay. Do you need to use the DOH form, or can a similar form or similar text in a will be acceptable as well? I think that was
okay. Well, that's what we're headed to now with the appointment of the agent. If you were to print out 4201, it comes out to about 7.5 pages. About 3 of those pages, just the layout of that form, and it says a format substantially similar to this. So it doesn't have to be exact. We did create a DOH official form and put it on the website, the 5211 form, and it's just as easy to print that out and use it. Or you can download it and put your logo at the top of it and just take the DOH form number off the bottom. Once you alter a DOH form, it's no longer a DOH form. So yeah, you don't have to use the exact form.
Okay.
All right.
Does it? I still have several others.
I'm sorry. They're coming in pretty good now.
Does a divorced wife have authority over an estranged daughter who has relinquished rights to cremation?
A divorced wife have rights over
an estranged daughter. I'm
not following that. An estranged daughter.
So if
you mean I'm guessing the disposition of the estranged daughter?
Yes, so if the daughter has removed herself, has waived her rights to cremation, can the ex-wife step in?
Well, again, it's depending on if there's nobody else in between. If there's a daughter that says I don't want anything to do with it. We have had that happen where people were divorced, but they still got along. Nobody else in the family wanted to do anything, and the ex-spouse stepped forward and said, "All right, I'll take care of things." Actually, that happened just recently because we had a call about that, and that's what we told the funeral home. Say, okay, have her sign that need statement. You're acting in good faith. She's acting in good faith. Nobody else is able or willing or competent. And the key word there was willing. This guy was not real popular with his family, probably is why he was divorced too. So yeah, it's, I mean, even the mailman can step in at that point. Nobody in the family is willing to do anything.
Can you please define
Right.
written instrument? Does it include a last will and testament?
Yes, it will. A written instrument, according to this subdivision, can be this 5211 form rather, or a will. And we'll talk about wills and agency. Actually, that's number 4. That's coming up right after this section. This section will go a lot faster than the previous ones, I promise. We good?
No, sorry. I'll ask this question, and then I will mention we do have something on our website regarding this, but how do you document that you have the majority in agreement?
I mean, just put it in writing. You could type up a statement, you know, that this, you're understanding that, you know, these are the individuals in this category of people with rights to disposition. You know, again, this law was just signed, this majority rule thing was just signed last week. And I know when it comes to cremation, you know, you're going to have to document that. I would write down whoever doesn't go along with it, write down that they declined the choice of cremation, and just put it in writing. Have as many of them sign it that'll sign it. And that's the very last slide that I do in this section is document everything. Because that's if it's not on paper, you can't prove it later. You know, that may be your only defense going down the road. So.
And right. We did kind of mock something up that we put on our website, just a sample form of something we thought that you could use for that reason.
Oh, great! I'm glad to hear that. I'm going to look at that when we're done here, because I'm sure we're going to be getting a lot of calls on that as well.
Yeah, yes. So. I have a couple more questions. Is that okay?
Yeah, sure.
Okay. I thought I heard in a past webinar that a deceased person cannot have both a domestic partner and a spouse. If they are married, even though separated for years, it wouldn't be possible for a domestic partner until that marriage is dissolved legally. Is that true?
That is correct. Yeah, that's maybe I wasn't entirely clear on that. Even if they've been living together for 20 years and have kids in common, if the deceased is still legally married and never had a divorce, that person is entitled to the Social Security and entitled to the rights of disposition. And that's where things can get sticky. This is why it's really important to have this subdivision 3 where we're going to talk about appointing an agent. And that was the example I used about the cremation service that we had, where this gentleman was living with a domestic partner for several years, but still had a spouse. And in order to supersede that spouse's rights, he had to appoint the domestic partner in writing. So it wasn't the domestic partnership that put her at the top of the list. It was this section that we're about to discuss now, the appointment of the agent.
Okay. When the decedent did not complete an agent form and also didn't have a written instrument stating an executor of the will, and a parent wants to make arrangements over an estranged child or children, does the parent have the right to do so? Does it make a difference when the death has occurred and the child or children are unreachable and it has been over a week? Does estrangement have any standing in any scenario, i.e. children, sibling, etc.? Estrangement has become a common inquiry where the parent or person further down the line wants to bypass the hierarchy because of the lack of contact with the decedent.
Yeah, and again, it's going to be, you know, in subdivision 2, we gave that hierarchy. Somebody down the list, further down the list, there can be 2 or 3 people above them and with a higher priority. But if those people are unavailable, unwilling, you can go down that list. That person, again, has to sign that statement in order to protect you and them. Sign that statement that we're going to talk about in subdivision 7, the at-need written statement. They're basically saying, I'm aware there's somebody else that may have more rights, but I'm claiming these rights because they're not available or they're incompetent. And then the onus is on them. If there's a dispute later, the funeral director can step back and say, well, I didn't make that call. You want to go to court? Take him to court. Don't take me to court.
Okay.
So,
okay.
Yeah, go ahead.
If you are saying that a person prearranged their funeral for a traditional burial, the family cannot change to a direct cremation to get extra money?
That's true. That is true. Because 4201 says you must follow the known directions of the decedent, and prearrangement is a very strong indicator of in fact, in this form, there's a place we'll talk about that again, where you have to emphasize, you have to indicate whether or not there is a pre-need arrangement, which would point to more directions that the agent must follow. So yes, and I know it happens all the time, and we get calls like that. At a funeral home call us that, yeah, the exact same scenario. The two children came in, mom had died. When dad died, mom made the arrangements, and then mom made her pre-arrangements. And then when she died, the kids came in and said, nah, we're not gonna do that. She's outlived all of her friends. We're just gonna do a cremation, give us the difference back. And since it was not irrevocable, she had selected the casket, she'd selected a burial place, she had all kinds of plans. And under 4201, you can't deviate from those plans. And he told me, if I don't do this, she's just going to go to my competition and transfer it there. And I said, well, it's your call, but if your competition does it, then he's in violation. He said, well, the only two people that will ever complain about it are the kids, and they're the ones who want the money. So he never told me which way it ended up, but I have a sense of what might have happened in that situation, which is why he never told me. But yeah, it does happen all the time. But 4201 says you have to follow the known instructions of the known desires of the decedent. Unless, of course, they want to have you build a pyramid and stuff that's not reasonable. Okay, then we can.
And just one more. Do you have any feeling on will registration of domestic partnership ever be a thing in upstate? I know it is downstate, but will it ever be upstate?
It's a local thing. I believe Buffalo and Rochester. I'm not sure about Syracuse. I believe they all have a domestic partnership registry. I mean, it's any municipality can. I don't believe there's a state registry for registering domestic partners at this time.
No.
I know there has been talk about it. I mean, that certainly would help clear up some confusion. But again, that's why, in subdivision 1, we had so much time spent on that one definition, was to try to say, here's all the possible things that should be considered in this definition.
One more, sorry. Who would be the person? Who would be the person who would take a funeral home to court if the pre-arrangements are not followed?
Well, it would depend. If the pre-arrangements are not followed, again, like the example I just gave, there was the two children. They were the ones asking to not follow the pre-arrangement, and those were pretty much the only ones who could have made a complaint, because they were next in line, and as far as that goes. But let's look at the scenario where you have multiple, and this is where this change in the law might bring up some interesting cases in the future. Let's say you have 4 children going to do a disposition. Mom made a pre-arrangement, and 3 of them say, nah, let's knock this down to a direct cremation, give us the money back. And the 4th one says, no, we're following mom's wishes. And the funeral director goes ahead, because majority rules now, and says, yeah, we'll do a direct cremation. That 4th one that was in dispute to begin with has every right to go to court and say, this funeral home did not follow the wishes of my mom, even though I was cut out of final disposition by this new change the law. They still have equal standing to sue, say, you're not complying with 4201. So that's something to bear in mind. It'll be interesting over the next few years to see what court cases I might be able to download that reflect any of these changes.
Okay, and then 1402 says a will. Does that include does the pre-arrangement fall under that?
I'm not sure what you're asking. Say it again.
It says 4201 says, quote, a will. Does the prearrangement fall under that?
By the prearrangement, I'm not sure what they mean by the prearrangement fall under the will.
Okay, I'll see if they come back with a more clarifying question. But otherwise, we're all set. No more questions.
Okay. All right. So we're up to subdivision 3 out of 11, and we've got about half an hour left. Department of Health does have the 5211 form on the website. Again, we have it in both English and in Spanish. And just a few things to remember about that here. There is a place where the agent must accept the appointment. Now, the agent is the person who's being appointed to be in control. This can be anybody, and that puts them at the very top of the list. That if you have somebody who's married and has adult children, has living parents, everybody on that list is alive, and they want to cut them all out, they can. They can appoint whoever they want. They can appoint their barber. They can appoint their minister. They can appoint their mailman. They can do whatever they want. That person is now legally in charge, and what they say goes. Now, and I will emphasize, of course, if there's written instructions about that, they got to follow those, but they get to, they're driving the car at that point. Now, here's another pending legislation here. It says there must be 2 witnesses, but notarization is not required. Okay, that's fine. You don't need to be, have the witnesses notarized. The witnesses are there to say, this person made this appointment and I saw them do that. Now, there is pending legislation to cut that down to only 1 witness. I don't know what the point of that was. I think that came out of COVID, where it was hard to get people together. Everybody was in quarantine. People were afraid to join up in groups. So that again has not been passed into law. And then it must indicate on the 5211 whether or not there is a pre-need contract. And this is where pre-need will give the agent further instruction. And I think there was one more. Yes, successors are recommended but not required. Now, a couple of interesting points that have come up over the past couple of years, and this has happened more than once. In fact, I think Randy McCullough and I have had this conversation more than once, where members have called and said, can a power of attorney appoint themselves? So we actually ended up pursuing an official legal opinion from our Department of Legal Affairs. And it hasn't been put in writing yet, but the preliminary discussion has been that under power of attorney law, a POA can appoint somebody acting on behalf of the individual, can appoint another individual to be an agent in control of disposition, but a power of attorney cannot appoint themselves. In other words, a POA cannot use their power to expand their power, and that would be considered an expansion of their power of attorney powers. So that answers that one. Another one that came up recently was a funeral home called, and they had a person that just passed away. And just before they passed away, they filled out the 5211. They appointed an individual, and they had 2 witnesses sign it. They knew they were on their way out. They wanted to get this done. The person then proceeded to die during the night, and the form was then sent to the funeral home. I think it was from a nursing home that was helping this family, but the agent had never had a chance to sign it. So the question came up, can the agent sign the acceptance after death? It was a good question. It's a very interesting question. Our legal department looked at that as well. And the way the form is laid out, if you look at our website, the witnesses only are witnessing the appointment of the agent. They're not witnessing the agent's acceptance. The agent's acceptance is at the end. There's nothing that would prohibit that agent from signing or accepting that appointment after death. So that was the only time I've ever had that come up, and I thought that was an interesting solution to that. The witnesses are witnessing the appointment, not the acceptance. Okay, subdivision 4, we'll deal with wills and agency very briefly. So prior to 4201 and this subdivision 3 where you can appoint somebody in writing, there was pretty much the only way to appoint somebody in control of your disposition was through a will. And the problem with that was the fact that not everybody has a will, not everybody has an estate, and also the wills generally tended not to be read until after disposition had occurred. So unless the person being appointed was made well aware of it and was ready to rush forward at the time of death, oftentimes those things kind of fell through the cracks. So in the absence of a 5211 or similar form, directions for disposition in a will be considered indicative of the decedent's wishes. But it's not often that people even put those instructions in a will. One of the individual cases that I printed out has to do with that, where an individual had a will, and no, I don't want to get into that now. If we get to subdivision 8, I'll go into it then. It's kind of an interesting case, but so a will can be indicative, but it's often not very clear. However, if somebody is appointed in a will, and the individual whose will it is wants to change that individual without going back to the lawyer and executing a new will, they can fill out the 5211, and that will supersede the will as long as it's done after the point of the will. So they can change their instructions just by filling out that form without having to change the actual will. So that's indicative that they've changed their mind. So the agent is appointed by a will after this 4201 law came into effect. The agent must sign a statement that they have no knowledge of any revocation, that's in subdivision 5, and that they have no knowledge of any other existing appointment of an agent form. So I know it sounds a little complicated, but there's a section that's tucked in here under this wills and agency that just tries to clarify that the agent being appointed can have their ability to donate anatomical gifts limited. Somewhere along the line when this was being crafted, somebody thought, well, what if the agent wants to donate anatomical gifts? Can they do that? And yeah, they can, but if the person who's appointing them doesn't want to make a donation, they can specify that in the 5211 form. So revocation, so let's talk about that. Any subsequent execution of the 5211, that appointment of an agent, will nullify any prior ones. In other words, they are date specific. How often can you do it? How frequently? How close together? There's no limit on that. Good example was I made pre-arrangements with a woman. The woman came into the funeral home with her daughter, with a daughter, I should say. They sat down at the table and they made arrangements. She picked out the casket, the burial vault. She picked out everything she wanted. And what stands out in my mind is that the bill came to $9,980, and she pulled out 10 envelopes of $1,000 cash each, and I had to make change for the last one. And got back, and we're all done. Little small talk as we're headed toward the door, and she says, "Oh, and by the way, this daughter here that's with me, I want her in charge of everything because my other daughter's no good." Oh, there's another daughter. I said, "Wait a minute. Okay, this could be a problem. So let's catch this before it becomes a problem." I told her about the 5211. We went back in, sat down. I rounded up a couple other staff people to act as witnesses. She made her daughter the person in charge. Everything's good, except for the fact about 3 weeks later, she came back with the other daughter and said, "I want to change that form and put her in charge because that first daughter is no good." So we went through the whole motion again. I kept a copy of the original one and I just wrote across it void and put the new one on top, stuck it back in her file. This happened at least 4 times. And I left the employment there before she passed away. I heard about 6 weeks after I left that she had died. I couldn't tell you which one of the daughters ended up being in charge, but they are date specific and you can change them as frequently as you want until the day you die. Any other action indicating your intent, such as creating a new will or specifying a new agent, will nullify that 5211. And this is an interesting thing. If the agent is the spouse or the domestic partner, divorce or dissolution of the partnership will nullify the appointment. Now, the first part, if the agent is the spouse, so the spouse normally would have the rights to control disposition anyways. So I don't know why a person would appoint their spouse, but if they had appointed their spouse and then they subsequently get divorced, that spouse can now no longer claim that agency. Domestic partner is the same way. If somebody appoints their domestic partner, especially in a situation where they're never divorced their original spouse, for example, but they can appoint a domestic partner. If they break up, that domestic partner cannot come forward again and do that. That's one of the cases that I was going to talk about that happened actually February 21 was when it was decided. It was a New York City case where the domestic partner was claiming the rights. The mother of the deceased was claiming the rights. They went to court. The mother of the deceased said, no, she's not a domestic partner because they broke up a few weeks ago, that sort of thing. So there was a back and forth. That's an interesting case. If I can get to it in the next 28 minutes or 25 minutes, then we'll talk about that. These next two sections, I definitely do not want to skip these at all, because this is what we've kind of been leading up to in a couple of areas. We're going to talk about some of the protections 4201 offers. And the first one is good faith of the agent. It states in subdivision 6 that a person who is acting reasonably and in good faith shall not be subject to civil liability for representing himself or herself to be the person in control of a decedent's disposition. In other words, this is answering some of those questions that came up earlier. They're acting reasonably. The person sitting across from you says, I'm the person in control of disposition. Yes, my brother has an adult son. We don't know where he is. Or yes, my dad has other siblings or other children, but we can't get in touch with them. If they're acting in good faith and they're saying, I'm going to be the one in control, they are safe from civil liability. In other words, if their family members then show up and want to sue them, okay, that's between them, but this is a protection for that individual. They shall not be held subject to civil liability for disposing of a decedent's remains if done with the reasonable belief that such a disposal is consistent with this section. In other words, they've done it in such a way that they believe it's consistent, that they believe, you know, I chose cremation because I believe he always wanted cremation, nothing to indicate that they didn't. And the third one I think is interesting, identifying a decedent. So this hasn't come up that I'm aware of where anybody's ever questioned the identification of a decedent by somebody claiming to be the person in control. But they are, if they're acting reasonably in good faith and they identify a decedent and that person is then cremated and turns up later that they were wrong, well, they were acting reasonably in good faith. You can't really punish them for that. So that's that part. Here's the part that I really want to emphasize is the good faith of the funeral director. And I've been hinting at this throughout this presentation. We've mentioned it before. And here's where we're going to talk about that form, the at-need written statement of the person in control of disposition. So under subdivision 7, it says no funeral firm shall be held liable for actions taken reasonably in good faith to carry out the written directions of a decedent as stated in a will or in that appointment of an agent form 5211. So let's think about that for a second. The firm cannot be held liable for actions taken reasonably in good faith to carry out the written directions. So here's the answer to that question. Yeah, the kids come in, they want to change it from a burial to a direct cremation on this pre-need. Well, here's where I've talked about that 5211 is a great time to introduce it, is when you are making pre-needs. When you're making a pre-need arrangement with an individual and they say, yeah, you know, this is what I want, and yeah, I just hope nobody ever tries to, you know, do this or do that or change it. That's a good point where you can bring this up and say, you want to make sure that you're going to get exactly what you want. Find the person that you trust the most and appoint them. And then if the funeral home goes by that, later on, the person dies, the funeral home follows the written instructions in that 5211, they've acted in good faith and they can't be held liable for that. Furthermore, it says, and you'll notice there's underlining here, This is in reference to that at-need written statement. No funeral firm shall be held liable for actions taken reasonably and good faith to carry out the directions of a person who represents that he or she is entitled to control the disposition. So what that's saying is, funeral homes acting reasonably in good faith to follow the instructions of somebody who's claiming that right. However, you will not be held liable provided that such action is taken only after requesting and receiving a written statement from that individual that they are designated in a will or a 5211, or that they have no knowledge of any 5211 or will, and that they have priority under subdivision 2 of the section. And what is their priority? They can claim priority, even if they're not the highest one on the list, if that other person on the list that supersedes them is not reasonably available or competent or willing. So we'll go to disputes, but at this point, I'm sure there must be a question. Ellie?
Oh, I'm sorry. Yeah, I was just going to say, sorry, my mute button was on. Okay.
No.
Can a funeral director sue a family if they don't follow pre-arrangement for economic loss?
Wow, that's a good question. That's never come up before. So the funeral home they don't follow the pre-arrangement and they take the money back, and now the funeral director wants to sue them for economic loss. That's a good question for them to bring up with their attorney. I don't think the public health law certainly doesn't address that. And pre-needs are under general business law, so I probably shouldn't comment too much on that. But that's something that's never crossed my mind before. Interesting.
And kind of related to that, can a child, the funeral director knows they can't change a pre-plan from a traditional call to a direct cremation, but can they change the arrangement to a viewing or visitation and then a cremation?
It would depend on what the actual instructions in the pre-need say, because that's come up before where, obviously a lot of people make pre-needs for themselves. They'll go in and say, I don't care what happens to me when I'm dead, just, let's do a direct cremation. That's what they sign up for and they pay for. That doesn't exclude the family from having a service afterward. But remember, if you're going to have a visitation prior to the cremation, it's no longer direct cremation. So, you can do the service with an urn and everything, unless they expressly forbid it. If somebody puts in their 5211 or in their pre, I don't want any services of any kind, and I've seen that done before, you have to abide by that. But that doesn't mean the family can't meet at, at Olive Garden or at the Elks Lodge or, at the VFW and do something to celebrate the life. You can't prevent that, or even at your facility. That wouldn't be a violation.
If children come into a funeral home and make pre-arrangements for their mother, are the arrangements still considered to be the wishes of the decedent?
Now, I was going to get to that when we get further down, and I don't think we're going to get there when we get to priority pre-need law, but there's two aspects of a pre-arrangement. There's the buyer and there's the beneficiary. Now, 90% of the time, it's the same individual. If I go in and make a pre-arrangement for myself, I'm both the purchaser and the beneficiary. But if my daughter were to go into a funeral home and make pre-arrangements for me, I'm the beneficiary, but my daughter's the purchaser, and the purchaser can change it at any time. So hopefully that makes sense.
Okay, is the agent necessarily the one who's financially in charge?
No, that actually has come up before, where somebody said, well, and that's the other thing, an agent can also change their mind at any time. We've had that happen before where somebody's appointed an agent, they sign the acceptance, they're good and happy with it, and then when the death actually occurs, they get cold feet and they say, "Ooh, wait a minute, I'm not sure I'm comfortable with this. I decline." And they can do that. They can decline after death, and then that whole 5211 is null and void at that point, unless they've. This is why the form actually has what's the term there? Not follow-up agents, alternative agents, if you want to. What was the word? My mind's gone blank on the term. Successors. Thank you. Successor agents, recommended, not required. But that has happened where a funeral home says, "Gee, we had this all put together, and then the guy declined. He doesn't want to do it." Well, then you're back to subdivision 2 with a priority of rights. You have to go back to the list, which kind of defeats the 5211. So, that's why they want the agent to accept that. What was the original question? I think I got off track there a little bit.
Is the agent financially responsible?
Oh, no, they are not financially responsible unless they agree to be. But a lot of times these are in place when there's already been a prepaid funeral arrangement, so that doesn't become an issue. But that is one of the reasons that I did hear about an agent declining at the last minute, was they were afraid they were going to be responsible. Because I guess there was a family dispute over the cost of one thing or another. They're like, hey, I don't want to be the agent in control anymore. All right.
All right. Can a resident registered at Funeral Home A work as a cemetery attendant in Funeral Home B on his day off?
It depends on what they're doing, because they can't be doing things that normally would require. In other words, they can't go and supervise a disposition, because the section on residents say they are under the employment of their sponsor, and they're not just a free agent to go around and do stuff like that. They have to be under the direction of their sponsor, because it's not really a license. It's a permit, basically, to act as a funeral director in many situations, such as transfers and services and things like that. And they can oversee dispositions, to the crematory cemetery for the firm that they're registered at. But they can't be a free agent and go off on their day off and hire themselves out like a trade person.
Is there something in writing from the Department of Health that would support the funeral director if a family wants to go against the wishes of the decedent? In other words, the pre-need contract is for a full service, but they want to change to a direct cremation. Where does it say that the family can't do that?
That's in 4201. If you want to download the entire law, like I said, it's about 7 pages. It basically comes right out and says that the person in control of disposition must adhere to the wishes of the deceased. And I'm looking for it here. Yeah, it's subdivision 2, paragraph C. The person in control of disposition pursuant to this section shall faithfully carry out the directions of the decedent to the extent lawful and practicable, including consideration of the financial capacity of the decedent's estate and other resources made available for disposition of the remains. The person in control of disposition shall also dispose of the decedent in a manner appropriate to the moral and individual beliefs and wishes of the decedent, provided that such beliefs and wishes do not conflict with the directions of the decedent. The person in control of disposition may seek to recover any costs related to the disposition from the fiduciary of the decedent's estate in accordance with Section 1811 of the Surrogates Court Procedure Act. So I think it's pretty clear. So 4201, you can download it. You can go on Find Law or Justia or one of those websites and just type in PHL 4201, and you should be able to find the entire text of the law.
Okay, what about when someone comes to make arrangements but are not honest about their legal relationship to deceased? For example, a person saying they are the son of the deceased when in fact they are not related or meet the standard to be considered a domestic partner. The funeral home may learn of this from a third party while services are being prepared for. How should the funeral director proceed?
Okay, well, first of all, again, subdivision 7, if you act in good faith and they've signed a statement, they can be lying. So they're no longer protected because they're not acting in good faith. But the funeral home's acting in good faith and they had them sign that statement, the at-need written statement of the person in control of disposition, that protects the funeral home. Now, if you haven't completed disposition and this information comes to you, you're under an obligation, I would believe at that point, to confront that individual and ask for clarification. And here we're into disputes, because here's this subdivision we're going into. There's another protection for you here where it says you cannot be held civilly liable for refusing to move forward. In fact, that's a good segue into this next section. And we've got 9 minutes left. So, and hopefully there'll be just maybe 3 or 4 minutes at the end to finish up the questions. Is there a few more that you have, or is that?
I do have a few more. Do you want to wait until the end?
Yeah, because I want to get through this part about it, because this answers that one that's currently in front of us, and we're pretty close here. And this part is really important. So we'll do this section, and then I'll just do the questions at that point. So disputes, it says that every dispute shall be resolved by a court of competent jurisdiction. So this goes back to some of those other questions. You have siblings that are equally, they have equal jurisdiction, and they're fighting over whatever it is, whether it's where to bury or cremation versus burial. Now with the change of the law on May 9th, majority rules, but if you've got 4 kids burying their last parent and 2 on cremation and 2 on burial, this is where subdivision 8 kicks in with disputes. They go to court of competent jurisdiction. And here's the protection that I was going to come to in that last question. No funeral director shall be held liable for refusal to provide services when the control of the disposition is contested. And they can hold on until they receive a court order or notification signed by all parties establishing control. In other words, get in the situation, again, 4 siblings, 2 want to go one way, 2 want to go the other. You don't have a clear majority under the new change of the law. And you tell them, okay, I'm stopping right now. Body's not going anywhere until you resolve this. Here's the rule. Here's the court. You're going to have to hire a lawyer, both sides. You're going to have to hire lawyers. You're going to have your lawyer go to the court, file the paperwork. The courts are normally put at the top of the docket because it's time sensitive, but this could take a few days. Oh, and by the way, our custodial care charges are X number of dollars a day. That oftentimes gets them moving. I mean, I'm not saying you should do that to like blackmail them into coming to a decision, but if you actually have a custodial charge on your GPL, don't be afraid to remind them of that. And we've had some of these disputes go on for days. We had one funeral from Down City about 3 years ago called. They had a body for almost 2 months. Well, these families fought back and forth and did stuff and went to court. And, the option to not go to court is have notification signed by all parties establishing control. When I say control, pick one person. Have that person sign the itemization, have them sign the CDI, have them sign the cremation author, have them do everything and document everything. So yeah, that's very important. There's a protection for you. You will not be held liable for refusal to move forward. Okay, so I want to talk very briefly. Zach, I know the time is really short and we're going to end with this, but I had several court decisions I was going to discuss, but there's one in particular that I do want to discuss because it goes back to the main point I've been saying throughout this about subdivision 7, good faith of the funeral provider, and it kind of ties in here. This was a court decision in 2014, Supreme Court of Monroe County, Paul Harris Funeral Home defendant. And this is a situation in which an individual was cremated. Apparently the wife and the husband were separated, but she was still the wife. She still had control. She went back to pick up the ashes, and the funeral home had given them to another individual who had showed up with a will saying, I'm the executor, I get the ashes. First mistake, funeral home should never try to interpret a will. Just somebody shows up with a will and says, here you go, look at this. They don't know if it's been probated. They don't know if it's been properly executed. call your attorney at that point. Anyways, they did hand off the ashes. Funeral home, the wife then tried to sue the funeral home. The funeral home tried to counter, saying, hey, wait a minute, we acted reasonably in good faith under Public Health Law 4201, Subdivision 7. The court came back and said, no, she can move forward on suing you because although Subdivision 7 gives you some protections, it also says the defendant failed to establish that they acted reasonably in good faith because it failed to request and receive the written statement required under Public Health Law 4201, Subdivision 7. In order to be entitled to such protections. In other words, the judge looked at the law the way that we just discussed it and said, yeah, Subdivision 7 does give you protections, but you forgot that one little point that I had underlined in the previous slide. So long as the individual signs a statement saying that they had control of disposition, the at-need written statement, that sort of thing. Okay, so we're going to stop there and take, I know it's really cool, 4 minutes left. You know, sometimes I do this exact same presentation and I got 20 minutes left at the end and no questions. I appreciate questions though, because it really helps. It really helps to bring up points that may not be specifically addressed. So I'll try to answer as many as I can as people start going back out and getting ready for their services and calling hours and whatnot.
Okay.
So,
if the deceased was legally separated from his second spouse at the time of death, does that mean the children can make the arrangements without getting her involved?
legal separation is not the same as divorce. So legal separation is more of a, oftentimes more of a financial agreement than anything. But divorce is what would sever that link in the hierarchy and priority of rights in Subdivision 2.
Is there a limit as to what an individual can put towards a celebration of life in a pre-need?
I would go, well, no, there's really not under the public health law. If it's on your GPL, you offer it. Yeah, that's great. Because that pre-need is only supposed to be with the funeral home. It's not supposed to be with, you know, the venue down the street. They can go and set up a separate thing with them if they want. Just bear in mind that if it should have flipped to an irrevocable down the road, county by county, some counties allow a certain dollar amount for food and beverage, et cetera. Some counties do not allow anything. So check with your local county on that.
Okay. Can a funeral home deny services based on a dispute between family members if the funeral home is not comfortable?
Yes, you are a private business. You have a right to refuse business. You can't discriminate. You can't just say, we don't handle anybody of the, you know, this particular faith or that particular, you know, we don't deal with veterans or something like that. You can't do that. But if you have a situation in which family members are in dispute, and we've had this happen multiple times, and that's when they call the bureau. I want you to make them do this. I'm like, no, they're a private business. We can't compel them to do anything. Just like if you went to a restaurant and your family's fighting, the restaurant can ask you to leave. Say, we're not serving you. They take it outside. Yeah, you have a lot more control than sometimes you realize. Okay.
If a person has a will, is an at-need statement still necessary?
Yeah, I would, in every case, I would get that at-need statement because you may find out later that the will is not valid. And again, you don't get into that sub category of being a will reader. Let the court decide how the will is structured and whether or not it's valid and who's in charge and that sort of thing. Anytime you do any arrangements, I would always get an at-need written statement. It's just good practice. It's free protection. It's the cheapest insurance you'll have. Let me put it that way, because it's free.
Is the at-need statement of agent form the document that the appointed agent should sign at the time of need.
Yeah, at the arrangements, who's ever going to be in charge, who's ever signing that itemization, have them sign the at-need written statement. That way you have it. Like I said, it's free insurance. I did it on every call, whether I needed to or not. Now, I know I've had funeral directors say, well, I don't do it on a cremation because it's on the DOS 1898 cremation authorization. That language is in there, and it's very, very similar, but hey, it doesn't hurt. Like I said, document, document, document. The more you can document, the safer you are.
Regarding the cremation authorization form, do each of the majority of the children or siblings need to sign that form?
Again, the law just changed in 4201, and the DOS 1898 form is actually under the jurisdiction of the Division of Cemeteries. We don't have any authority on that. My understanding, though, in talking with Louis Polishuk and being on the cemetery board, is that up until May 9th, they followed 4201 in their priority of control, and they did require that everybody of equal standing had to sign. So I have talked with Louis when this legislation was first being hammered out, and they anticipated that should it go through, which it has now, that there would be some modification. I haven't seen anything. I haven't been to the website to check. I don't know if they had something pre-written to post in case it did go through. But I would defer to their website for specifics now that that has happened, especially if you end up with a situation where there is, 3 siblings versus 1 or whatever. They're not in agreement. That would be a good time to reach out to the Division of Cemeteries and get a more specific ruling.
Okay, the decedent has an agent, but the agent is not the person who will be responsible financially. The person who will be paying all the expenses does not agree on the choices for disposition and will not be financially responsible unless their wishes are met. Now what?
That's a business decision there. The person who's in control of disposition is in control. If the person who was going to pay the bill, first of all, why were they paying the bill? Were they the beneficiary of an insurance policy or whatever it was? The estate can always be billed if there is an estate. That's not always the case. And a lot of these things end up in court. The owner of the firm that I used to manage was very, very good at taking people to court. He kind of ended up with a reputation after a while because he took so many different people to court to get payment. But the person in control of disposition doesn't necessarily have to be the person responsible for the payment.
Are there still 2 at-need statement forms, the person one and the agent one?
No, I think where there might be some confusion is the at-need written statement is anybody who's making the funeral arrangements should sign that. The 5211 is not as common. That's the person prior to death signs that to appoint somebody. Now, let's say I appointed my barber to be in control of my disposition when I die. Let's say I just don't trust anybody in my family, and I go to my barber and say, would you be in control? I don't want any of my kids or my wife or anybody in charge. Now he's the person at the top of the list. When I die, he comes into the funeral home, makes arrangements. I would still have him as the funeral director sign that at-need statement of the person in control. And he would circle the thing at the very top of that list that says person appointed in writing.
And I know we discussed this as more of a Division of Cemeteries, but do you know if they plan on adding a notary requirement to the cremation forms?
I don't believe so. I've never heard anything about that. And because they still require witnessing for all the signatures, in fact, prior to COVID, their rule was they wouldn't accept it if it was notarized. It had to be witnessed. Because the only time they would accept a notarization, it had to be witnessed by a licensed funeral director. That's their caveat. It's on their form. It has to be licensed. It has to be witnessed by a licensed funeral director. The only time they've accepted notarization is if the person died out of state, or how did that work? The person in control was out of state, and there was no licensed funeral, New York State licensed funeral director to witness it there. But again, that's a better question for Lewis. And he'll be doing a law program on Friday if you want to get more law credits. So hopefully, by the way, for those of you who are still online here, we had, what was it, 600, and I had it written down earlier, I lost my spot. Basically, yeah, 630 people signed up. Yeah. Oh, yeah. There it is. 743 people signed up for this particular presentation, which works out to roughly 20% of all licensed funeral directors in the state, which means you're going to have to be a little more quick in the next biennium. You don't want to get backed up in the last 2 months of getting credits. I just thought that was interesting. 20% of you are still looking for law credits at this late date. So I know we're after the hour now. I don't know how many people are still online.
I just have one more question, and it's not related to the webinar, but someone is wondering how the DMV picture license thing is going.
How is that going? That is, it's extremely slow. You've all seen glaciers. That's the way it's going. I actually, I have a mock-up of the plastic card. We've had the language on the registration forms for 3 bienniums now. I do have a meeting scheduled again with people in budget and finance to discuss the setup charges for this new system. Obviously, it's not going to be on this biennium. My goal, and this is not a promise, this is a goal, is to have the DMV picture pocket cards available in the next biennium. I'm really pushing for that. I know they came very close prior to my arrival in Albany, and it got bumped because of the lifetime fisherman licenses. There were 40,000 fishermen and only 5,000 funeral directors, so they took priority. So hopefully nothing like that pops up in between, but we are working on it. It's moving slowly. There's an MOU that we have to have in place between our legal department and the DMV's legal department, and then there's a new vendor that has come on board that'll be producing the cards. So there's some new things that have got to be looked at there, but we are working toward it.
Okay, that is it. And I appreciate Tom so much. And we can't thank you enough for doing this for us. I know it's kind of close to the end of the biennium, but we always appreciate this opportunity. So everyone should remember it'll take about 7 to 10 business days for your credit to appear on the portal. And if you have any questions, feel free to give us a call here. And of course, Tom is always available for questions as well. I hope everyone has a great rest of the day.
And I'll see you at the Turning Stone, hopefully.
Yes, we are looking forward to it.
All right, have a good day.
Thank you.